the case was simply just reset for restitution hearing. So it looks like you didn't do anything.
And haven't actually sentenced yet.
I don't believe you did.
Hold on. This moment is more important than it might sound. The judge is basically saying the sentencing hasn't happened yet, which means the defendant still has a chance to influence the outcome. In court, timing matters. If a defendant shows responsibility before sentencing, like agreeing to pay restitution, it can sometimes mean the difference between probation and jail. So the big question right now is, will she take that opportunity?
Okay. And all right, ma'am, you're Janisha Leonard. And Ms. Leonard's here in 3 cases. One is cause number 25 DCCR 0297. That is the new theft of property case, a state jail felony she entered plea of guilty to. And then we have 2 MTRPs, one in cause number 19-33340, theft of property, and 20-36095, a theft of service. And in each of those cases,
This is where things get serious. Being accused of a new crime while already on probation is one of the fastest ways to end up behind bars. Judges often view it as proof that earlier chances didn't work. So even though this new charge is serious on its own, the real danger here is that it could trigger consequences for the previous cases too.
is she on a deferred in both of those? Or is it straight? I'm trying to, sorry, I should have. Is it a deferred probation?
Let's see, Judge.
No, they're straight probation, Judge.
Okay.
Yes.
So they were deferred, and then we were here, and then revoked that deferred and reassessed and did the 2/5 at some point. Is that correct?
The last information I have in my files is she was on straight post-conviction probation. I don't know if she initially was on deferred or not.
Yeah.
I don't
Okay.
know.
All right. Yeah. Okay. So the biggest issue, one of the bigger issues that I had when we were here for sentencing, based just on paper and the appearance of this, I don't disagree with Mr. Coleman's assessment of the case with the criminal history of Ms. Leonard with these types of offenses, and which the criminal history is these 3 cases. There aren't any other cases. And the new
Notice what the judge is doing here. She's carefully laying out the defendant's entire criminal history on the record. That's not just procedure. Judges often do this right before making a major decision about sentencing. And interestingly, the judge points out something that could actually help the defendant. There aren't any additional cases beyond these 3.
offense date was August of 23. And it's kind of just unknown, it sounds like, why that case was delayed in prosecution. Doesn't look like anybody knows. And so the time frame between that and now, and the lack of any other cases while Miss Leonard has been out and on probation during that time and doing well, it looks like otherwise on probation, is what leads me to potentially move forward with continuing the probation potentially on the others and giving her a probation on this one. So there was no agreement on any of these, but it looks like there was an issue with regard to the amount of restitution. So let's go forward with that. Have you guys come to any type of agreement on the restitution?
We are very
We're
far
very far apart, Judge, and I guess one of the issues that we have is I believe Mr. Coleman's got some exhibits that are going to go back to 2022. I would object to looking at anything outside the range in the indictment. The indictment goes from August 23, and get you the exact dates.
Let me get it pulled up as well.
August 24th, 23 to September 4th, 23.
Okay.
I would ask that we remain in that range.
That line right there is a huge clue. When a judge starts talking about a defendant showing improvement, it usually means they're considering a second chance. But there's still a major obstacle ahead, the restitution dispute. And as we're about to see, the lawyers are about to clash over a very technical but extremely important legal detail.
I would think legally that would be probably what I would need to do.
Judge, it's a continuing course of conduct. The theft is. I'll be honest, Mr. Ross just brought that to my attention this morning. I haven't had a chance to research it. but he certainly has had all of the restitution information showing that it's going back in 2022 in the discussion. So it's not an unfair surprise for him to know that we're looking for restitution going back.
Well, but I think the allegations, and obviously I understand the honor about as well as any of you guys, but those are some pretty specific. I mean, that's a very short time frame that is alleged in the indictment. Talking what, 4 days?
Well,
5 days?
yeah, it's,
Well, yeah,
it's from August 24th, 2023 to September 4th.
I'm sorry, I'm looking at an old indictment. I'm sorry, hold on. I was looking at another
About
case.
10 days maybe.
Hold on. So in the new call number. So yeah, this one is August 24th of 2023 through September 4th of 2023. So less than a couple of weeks, a couple of weeks or so is the allegation. And I don't want to have to keep coming back here. But I think to go back, if it was a few weeks off or a month or two off, but if we're talking years of requesting that, then I think that's something that indictment needs to allege. And so we can go forward with that time frame today. I think legally that's where we need to be. She's already pled to it, so I think it's kind of late to amend the indictment. So with regard to the time frame of August 24th through September 4th of 2023, what is the amount between that time frame? Do you guys have that? Or need some time to look at it again to make... And the unfortunate, I want to make sure you guys know how I am. If someone has had something stolen, I want them made whole as much as possible. I just don't think we can go back that far legally. So I want to make sure that the victim understands that as well, that we've got kind of a limited time frame here that we need to move forward on if I'm going to order restitution and probation. Y'all need a minute to do some math?
Just a quick minute.
Yeah, y'all go ahead, y'all have a seat based on, I guess, that. See if there's something you guys agree to as far as that time.
Just based on an honor about date, and they understand that the court's willing to kind of go back a number of weeks. I've got receipts to go back as far as, I believe, August the 9th of 2023. I don't know that would necessarily be, I think that would be enveloped in the honor about.
I wouldn't disagree with that.
So
August 9th, 2023. And then what was the last?
The last
is that the September 4th date?
The last one is, I don't have misquote. Let's see here. September the 4th is the last day.
All right. So you guys figure out what between August 9th and September 4th of 2023 number is and see if there's an agreement on that number. If for some reason there's not, then I can take a look at the receipts that you guys have and we'll go forward. I'll hold it for a few minutes. We're back on the record. Cause numbers 25 DCCR 0297, 19 33340, and 20 36095. Y'all have an opportunity to kind of go back through the receipts as far as that time frame legally that we can kind of talk about on this case.
We have to.
Mr. Coleman came up with a number of $2,407. In speaking with Ms. Leonard, her recollection actually is a little bit more than that. She thinks somewhere between $3,000 and $4,000. We had agreed to, or we had offered $3,500, and I think that Ms. Leonard feels comfortable paying back as far as restitution.
So if she agrees that it's between $3,500 and $4,000, then
$3,000 and $4,000.
3 and 4, I'm more inclined to go on the higher end of that, just based on the nature of the time frame that we're unable legally to look back on. And so I would be inclined to order the $4,000, Mr. Coleman.
Judge, that makes perfect sense. I've spoken with the complainant who is here today, the district manager for Sutherland's, His position is he'd like to be heard by the court. He was thinking that if the defendant was placed on probation, that they'd be getting a lot more in the way of restitution. I explained to him how we arrived at where we are, but he still wants to address the court and quite possibly ask the court to reconsider. If he's not going to get more than what he's getting in the way of restitution, he would want the court to reconsider some type of form of jail time.
Okay. And sir, you can come on up. Ms. Leonard, if you'll just kind of slide around.
Right, for the record, the witness's name is David Powell.
Thank you. Good morning, Mr. Powell. Thank you for being patient with us this morning. It was a big morning here. Mr. Powell, would you please raise your right hand?
Yes.
Do you swear affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. Thank you, sir.
Mhm.
And Mr. Powell, you kind of heard where we are on this legally. I understand there's a significant amount of restitution.
This might sound like a minor technicality, but in criminal law, it's a huge deal. The indictment is basically the official rulebook for the case. If prosecutors want restitution for losses outside those dates, they usually have to charge those dates in the indictment. Otherwise, the judge's hands can be tied, even if everyone believes the theft happened earlier. And that's the judge drawing a firm legal boundary. Even though the victim may believe much more money was taken, the court can only order restitution tied to the charges actually listed in the case. It's a reminder that courtrooms don't just run on emotion. They run on procedure and precise legal rules.